The Supreme Court just changed the rules on gun permits forever, not tweaked them, not adjusted them, changed them forever. And if you carry a firearm, or you've been trying to, what happened in that courtroom affects you directly. It affects what you can legally do, where you can legally go, and what the government can and cannot demand from you before you exercise your Second Amendment rights. But here's the part that should scare you. Most people heard a headline and moved on. They have no idea what actually happened or what it actually means for them on the street, in their car, at their job, walking to their front door at night. And that ignorance could land you in handcuffs faster than you can say Second Amendment. Because while your rights just expanded more than they have in the last 100 years, the states fighting this ruling are counting on you not knowing the details. That's what this video is about. I'm going to break down exactly what the Supreme Court ruled, what it means state by state, which tricks certain states are playing to limit your rights anyway, what myths are already spreading that could get you arrested, and what's still being fought in courts right now. By the end of this video, you'll know more about your gun rights than 95% of Americans. But before we get into it, are you subscribed? Because what I'm about to walk you through is the kind of legal information that the mainstream media either botches completely or buries in jargon nobody understands. Laws are changing week by week right now. New court decisions are dropping constantly. Being the last to know means being the first to get caught in the crossfire of a legal battle you didn't even know was happening. Hit subscribe and turn on notifications before we go any further. Now let's get into it. The case is called New York State Rifle and Pistol Association versus Bruin, decided June 23, 2022. 6-3 decision. Justice Clarence Thomas wrote the majority opinion. And this wasn't a close call. It wasn't some narrow technical ruling that only applies to one city or one specific law. This was a sweeping constitutional decision that reaches into every single state in America. Here's the backstory. New York had a law called the Sullivan Act that had been on the books for over 100 years. It was called a proper cause requirement. What that means is, if you wanted a concealed carry permit in New York, you had to prove to the government that you had a special reason to carry a gun. Not just self-defense. Everybody wants self-defense. That wasn't enough. You had to prove your life was specifically in danger. You had to convince a government official, someone you've probably never met, someone who has no idea who you are, that your reason to carry was good enough, that your situation was dangerous enough, that your need was real enough. Most people couldn't do that. Most people got denied. If you ran a small business and carried cash, maybe not good enough. If you worked late shifts alone, maybe not good enough. If you'd been threatened, maybe not good enough. It was entirely up to whoever was sitting behind that desk to decide whether your life and your safety met their standard. And Justice Thomas, in the majority opinion, made it crystal clear. The Second Amendment is not a second-class right subject to the whims of a local sheriff or a licensing clerk. You don't need a special reason to exercise your right to free speech. You don't need one to carry a firearm for self-defense. 2 men in New York applied for unrestricted concealed carry licenses. Both of them wanted to carry for general self-defense. No special circumstances, no dramatic threats. Just two law-abiding citizens who believed the Second Amendment gave them the right to protect themselves in public. New York said no. General self-defense isn't good enough. You need something more. So they sued, and they won. The Supreme Court ruled that law-abiding Americans have a constitutional right to carry a handgun in public for self-defense. The state cannot force you to prove that your reason is special enough. The state cannot demand you justify your constitutional right to some bureaucrat who may or may not feel like approving you that day. The Second Amendment is your reason. Full stop. Now here's what most people get wrong about this ruling. They hear New York case, and they think it only affects New York. That is completely wrong. This decision applies to every state in America, every single one. But it hits certain states harder than others. Before this ruling, America was split into two worlds. Shall-issue states, where if you pass the background check and complete the required training, the state shall give you the permit. No discretion, no judgment calls. And may-issue states, where even if you're a perfectly law-abiding citizen, the state may give you a permit. Or they may not. Their choice, their discretion, their judgment about whether you deserve your constitutional rights. The states that had may-issue systems were New York, California, New Jersey, Maryland, Massachusetts, Hawaii, and a handful of others depending on the county. Together, these states covered over 100 million Americans. More than 1/3 of the entire country was living under a system where the government could deny your carry permit for any reason, or no reason at all. That system is now unconstitutional. Think about the magnitude of that. Millions of people who were told no for a century are now legally entitled to a yes, and these are real people. The woman in California who was stalked by a former partner and was denied a permit because the sheriff didn't think the threat was serious enough, she qualifies now. The small business owner in New York who carries cash deposits twice a week and was told that's not a special enough reason, he qualifies now. a female jeweler in California who transports high-value assets and had to prove she was in more danger than the general public. She doesn't have to prove that anymore. The burden of proof has shifted from the citizen to the state. The state now has to prove why you shouldn't have a permit, not the other way around. The regular person in New Jersey who just believes in being prepared and was denied because they didn't have a dangerous enough job or a dramatic enough story, they qualify now. Think about what that means on a human level. For 10 years, people jumped through every hoop, told their most traumatic stories to strangers, begged officials to take their fear seriously, and returned away anyway. That era of begging is over. But don't go running out the door with a holster just yet. The Supreme Court didn't say no permits required. They said no discretion allowed. States can still require you to get a permit. That's legal. They can still run a background check, require safety training, charge fees, and make you go through an application process. All of that is still allowed. What they cannot do is deny you because they don't think your reason is good enough. What they cannot do is make you beg. What they cannot do is treat the Second Amendment like a privilege they hand out when they feel generous. Now stay with me here, because this next section is the part that almost nobody covers, and it might be the most important thing in this entire video. Bruen didn't just kill may issue permits. It changed how every single gun law in America gets evaluated by courts from this point forward. Before Bruen, courts used something called intermediate scrutiny. What that means is, when a gun law was challenged, the government just had to show that the law was reasonably related to an important government interest. Public safety is an important government interest. So almost every gun law passed that test. Courts were rubber stamping gun control laws left and right. The government almost always won. That test is now dead. Bruen replaced it with a completely different and dramatically higher standard. Now, when a gun law is challenged in court, the government has to prove that the law fits within America's historical tradition of firearm regulation. They have to go back to the founding era, 1791, when the Second Amendment was ratified, or 1868, when the 14th Amendment was ratified, and find real historical examples of similar laws. If they can't find those examples from the founding era, the modern law is presumptively unconstitutional. It's not enough to say, this law makes people safer. You have to show that laws like this actually existed in 1791. You have to prove your modern restriction has a legitimate historical ancestor. That is a tidal wave for gun law in America, because a lot of modern gun laws have absolutely no founding era equivalent. Nobody in 1791 was passing laws about magazine capacity limits. Nobody was banning so-called assault weapons. Nobody had red flag laws. These are modern inventions with no historical parallel. Under the old standard, that didn't matter. Under the Bruen standard, it matters enormously. Gun rights attorneys all over the country immediately recognized what this meant. The moment Bruen dropped, they started filing challenges to laws that had been untouchable for decades. Assault weapon bans, magazine limits, waiting periods, red flag laws, licensing requirements that go beyond basic background checks, all of them being challenged right now using the Bruen standard as a sledgehammer, and some of them are losing in court. Cases that would have been dismissed with barely a second glance under intermediate scrutiny are now surviving, advancing, and in some instances winning outright. This is a legal earthquake that is still shaking, and the aftershocks are going to keep coming for years. Now, if you think the politicians in Albany, Sacramento, or Trenton just packed up their bags and said, "Fair play, you win," you are dangerously mistaken. What we are seeing right now is one of the greatest examples of legal malicious compliance in American history. These states have shifted from denying you a permit to making the permit nearly impossible to use. They can't legally say no to your application anymore, so they've started saying yes, but. And that but is engineered to land you in a jail cell if you're not paying attention. Let me walk you through exactly what they're doing. The first move is what you could call the sensitive places explosion. The Supreme Court acknowledged that states can still prohibit firearms in certain sensitive locations, government buildings, schools, that have a historical tradition of being off limits. The states took that inch and tried to run a marathon with it. New York, almost immediately after the ruling, passed the Concealed Carry Improvement Act. They couldn't require proper cause anymore, the Supreme Court killed that, but they did the next best thing. They designated enormous parts of the state as off limits for carrying. Times Square, public transit, parks, restaurants that serve alcohol, houses of worship without explicit permission, zoos, stadiums, hospitals. In some versions of these new laws, the only place you could legally carry was in the middle of a deserted street. They are deliberately creating a patchwork quilt of restrictions so dense that a law-abiding permit holder unknowingly commits a felony just by walking across the street to get a coffee. The second move is what gun rights advocates have started calling the vampire rule. Historically, if a private business didn't want guns on their property, they had to post a sign saying, "No guns allowed." The burden was on the business to make their restriction known. New York tried to flip the entire script. They passed a law saying all private property is automatically gun-free unless the owner posts a sign explicitly welcoming firearms. Think about how many shops in Manhattan or downtown Los Angeles are going to put up a guns welcome sign. Almost none. Most business owners don't want the controversy, the insurance implications, or the public perception that comes with it. The result is that an entire urban landscape becomes effectively gun-free without a single official gun-free zone sign ever going up. It's a backdoor ban on carrying in any populated area, dressed up in the language of private property rights. The third move is the social media dragnet. Some states began requiring permit applicants to hand over a list of every social media account they've used in the last 3 years. The stated reason? So a character analyst can review your posts and comments to decide if you're a fit person to carry. But here's the reality. This is the exact same subjective character judgment the Supreme Court just ruled unconstitutional, just dressed up in a digital suit. Instead of a bureaucrat deciding your life isn't dangerous enough, now a bureaucrat is scrolling through your memes to decide your personality isn't trustworthy enough. Different packaging, same unconstitutional substance. Multiple lawsuits are already working through the courts challenging every single one of these tactics. California followed the same playbook as New York. Technically switched to shall issue to comply with Bruin, then expanded their list of sensitive places to include beaches, libraries, playgrounds, government buildings, and public gatherings. That expansion is being challenged in federal court right now. New Jersey and Maryland followed similar patterns. Hawaii fought the hardest. Hawaii actually had a state court attempt to argue that the Second Amendment doesn't apply the same way there because of the state's unique history and traditions. Federal courts rejected that argument. Hawaii has had to comply. Federal judges are looking at these response acts and asking a simple question. Was there a law in 1791 that banned carrying a flintlock pistol in a public park? The answer is almost always no. And that's where the Bruin standard is proving to be a nightmare for gun control advocates. For every new restriction a state passes, a pro-Second Amendment legal group is filing a lawsuit using the historical tradition test to dismantle it. This is a silent war happening in courtrooms across the country. The map of gun rights in America is being redrawn in real time. Meanwhile, in shall-issue states that were already compliant before Bruin, Texas, Florida, Arizona, Tennessee, and most of the South and Midwest, the ruling confirmed what was already the law on the ground. But those residents benefit enormously from the new legal standard going forward because it protects their existing rights from being eroded through future legislation. Now I need to slow down and address something, because right now the internet is flooded with self-proclaimed constitutional experts who read one headline and think they're suddenly immune to state law. That kind of thinking will land you in a cell faster than you can say Second Amendment. Just because a law is unconstitutional doesn't mean a cop won't handcuff you for breaking it today. It means your lawyer can fight it in 3 years while you sit in a legal mess you never needed to be in. My goal here is to make sure you never need that lawyer in the first place. So let's clear up the 3 biggest myths spreading right now before one of them gets you arrested. Myth number 1. Bruin means you can carry anywhere without any permit. This is the most dangerous lie circulating right now. The Supreme Court did not mandate constitutional carry, which is permitless carry, for all 50 states. They only mandated shall issue. If your state requires a permit to carry, and most states do, you still need to get one. If you carry without a permit in a state that requires one, you are committing a crime, and Bruin will not be a get-out-of-jail-free card. The court simply said the state can't be discriminatory about who gets the permit, as long as you are a law-abiding citizen who meets the requirements. The permit requirement itself is still completely legal. Myth number 2. Gun-free zones are all illegal now. Also wrong, and this one will get people into serious trouble. While many sensitive place laws are being challenged and some are being struck down, they are often stayed, meaning put on hold, during the appeals process. You need to know the specific status of the law in your zip code today, not the status of some lawsuit working through a district court. Just because a judge ruled a law unconstitutional doesn't mean it's immediately unenforceable. Always check whether an injunction is in place before you make decisions about where you carry. Gun-free zones still exist today, and they still carry serious legal consequences. Myth number 3. Bruin only applies to concealed carry. This one is partially true and partially false. The case itself was about concealed carry because that's the system New York had in place. But the constitutional principle the court established, that you have a right to bear arms in public, applies to the act of carrying generally, not specifically to concealed carry. Open carry advocates are already filing lawsuits using Bruin as the foundation for challenging open carry restrictions in states like California and Florida. The legal reasoning is the same. If the government can't restrict your right to carry without finding a historical justification, that logic applies to how you carry, not just whether you carry. The building isn't finished yet, but the foundation is there. Now let's zoom out, because this ruling doesn't exist in a vacuum. It's the third act in a story that's been building for 15 years, and understanding the full arc tells you exactly where this is all heading. In 2008, District of Columbia versus Heller, the Supreme Court ruled for the first time that the Second Amendment protects an individual right to own a gun for self-defense in your home. Before that decision, some courts said the Second Amendment only applied to militias and had no relevance to individual citizens. Heller ended that debate once and for all. In 2010, McDonald versus Chicago, the court ruled that this individual right applies to state and local governments, not just the federal government. Before McDonald, cities and states were arguing they could do whatever they wanted with gun laws within their own borders. McDonald said no. The individual right Heller established applies everywhere in America, at every level of government. In 2022, Bruin, the court extended that right beyond the front door. You don't just have the right to keep a firearm, you have the right to bear one. In public. For self-defense. Not just in your living room, not just on your property, but out in the world where you actually live your life. Heller, McDonald, Bruin, the home, the states, public carry, each case built on the one before it, each decision expanded the constitutional floor beneath gun rights. The pattern is not subtle, and because of the new history and tradition test, the cases working their way through courts right now could reshape far more than just permit systems. Let's look at what's actually in the pipeline. Assault weapon bans first. States like Illinois and Washington have passed laws banning certain semi-automatic rifles. Under the Bruin standard, the government has to find a historical analog from the 1700s or 1800s for banning an entire class of weapons in common use. There is no such analog. Cases like Beavis versus Naperville are headed toward the Supreme Court, and the historical argument against these bans is extremely strong. Magazine capacity limits next. Courts are now forced to examine the history of multi-shot firearms. Repeating arms existed well before the 14th Amendment was ratified. The argument that a 15-round magazine is historically unprecedented is falling apart in courtrooms right now. Age restrictions are also under pressure. Can a state prohibit 18 to 20-year-olds from carrying? The courts are looking at 18th century history, where 18-year-olds were not just allowed, but often required to own firearms for militia service. The history and tradition test is proving to be a serious obstacle for these restrictions. Red flag laws, waiting periods, and restrictions on suppressors, all of them are being litigated using the Bruin framework. Not all of them will fall. Some will find historical analogs that satisfy the standard, but a significant number of modern gun control laws were written in an era when courts applied a far more forgiving standard. They were designed to survive intermediate scrutiny, not history and tradition scrutiny. Those are two entirely different tests, and the laws built for the old test are struggling badly under the new one. The practical effect of this is that we are watching a mass reordering of American gun law in real time. Every week, new decisions are coming down from district courts and circuit courts around the country. Some restrictions are being upheld, some are being struck down, some are being struck down, and then stayed pending appeal, which means they're technically invalid but still being enforced while the legal fight continues. This is the most legally active moment for Second Amendment rights in American history. The landscape right now is genuinely shifting under everyone's feet. We are living through what legal scholars are already calling a Second Amendment renaissance. The direction of the courts is not ambiguous. Let me bring this back to what it means for real people, because self-defense is deeply, viscerally personal. Nobody knows the risks in your life better than you do. Nobody knows the route you drive home late at night. Nobody knows who's been making you uncomfortable in your parking lot. Nobody knows the neighborhood where your kids play. Nobody knows your life. For over 100 years, states like New York told you that didn't matter. They told you that some permit official sitting in a government office who has never seen your neighborhood, never walked to your car late at night, never been in a situation where they felt genuinely unsafe, got to decide whether your fear was justified, whether your situation was dangerous enough, whether you deserved the right to protect yourself. That is not what constitutional rights are supposed to look like. Rights are not supposed to require you to perform your danger for a stranger. Rights are not supposed to be granted by bureaucrats who may or may not feel like granting them that day. The Supreme Court recognized something fundamental with this ruling. It said, you are an adult. You are a citizen. You have a right. And the government's job is to regulate within that right, not to decide who gets one. That is a meaningful shift. And it matters not just for gun owners, but for the foundational principle that constitutional rights are real, enforceable, and not subject to the personal discretion of government officials. So here is where things stand right now, and here is what you need to do. If you live in a former May-issue state, California, New York, New Jersey, Maryland, Massachusetts, Hawaii, the proper cause and special need requirements are gone, dead, unconstitutional. Get your application in. You no longer have to justify your fear or prove your life is more endangered than your neighbor's. You pass the background check, you meet the requirements, you get the permit. The state has to approve you. Once you have that permit, learn the map of your state right now, not the map from 6 months ago, not the map from a blog post someone wrote the week after Bruin dropped, the current map, today, because it is changing week by week as courts issue new rulings, injunctions, and stays on these Response Act restrictions. States like New York and California are still fighting for every inch of ground, and the legal landscape in those states looks different this week than it did last month. What was a felony zone 3 months ago might have been struck down last week. What was legal to carry in last fall might now be restricted, pending a new court order. You owe it to yourself to stay current, because the law in these active litigation states is genuinely moving that fast. And get trained. A permit is a piece of paper. Proficiency is what actually protects you and the people around you. Don't be the person who finally has the right but lacks the skill to exercise it responsibly. The 3 things to lock in are these. May issue permit systems are unconstitutional and gone. If your state used to require you to prove special need or proper cause, that requirement no longer exists, and you can apply as a law-abiding citizen. All gun laws are now being evaluated under a much stricter historical standard, meaning the government has to prove any gun restriction they want to impose matches historical tradition from the founding era, a bar that a significant number of modern gun laws simply cannot clear. And your Second Amendment rights are the strongest they have been in modern American history, with the legal battles being fought right now set to determine how much stronger they get. One critical note before you go. Everything covered here is educational information. It is not legal advice. Gun laws are complex and they vary significantly state by state, county by county, and sometimes city by city. What's legal in Texas may not be legal in California. What's being struck down in New York may not apply where you live. What's on the books today may have changed by the time you watch this. For anything related to your specific situation, talk to a qualified firearms attorney in your state. Knowing the broad legal landscape is important. Knowing exactly how it applies to your specific life and location is essential. Your reason for carrying is not a special need. It is not a justifiable cause. It is not something you have to prove to anyone sitting behind a government desk. Your reason is the Second Amendment, and for the first time in a century, the highest court in the land agrees with you. Drop a comment below and tell me what state you're in and what you've seen change in your local permit process since this ruling came down. Have you applied? Have you been approved? Are you watching your state fight this in court? I read every single comment. I want to know what you're seeing on the ground where you live. If this gave you information you didn't have before, and I'm confident it did, hit that like button and share it with someone who owns a firearm or is thinking about getting their carry permit. They need to see this. Your rights are expanding. Know them, exercise them, stay legal, stay safe, and stay informed, because in a legal landscape moving this fast, knowledge is the most important thing you can carry.